case briefs, and so much more. LSData's got what you're looking for.
The Supreme Court of Texas heard the 1990 case of Evans v. Pollock, which centered around the concept of implied reciprocal negative easements and whether or not certain deed restrictions applied to all or just some properties of a subdivision. The doctrine of implied reciprocal negative easements allows property owners to enforce similar restrictions on similarly situated lots if they have notice of the restrictions. The dispute arose when the subdivision owner sold lots with restrictive covenants as part of a development plan that was not agreed upon by the disputed parties. The trial court initially ruled that the restrictive covenants only applied to lakefront lots, while the hilltop block was exempt. However, the Court of Appeals overturned this decision, stating that a restrictive covenant could only apply if the entire subdivision tract was included in the general plan of development. The Supreme Court disagreed with the Court of Appeals ruling, stating that as long as a clearly defined restricted district existed and restrictions applied to it, the doctrine could apply to those lots. The court held that the doctrine of implied reciprocal negative easements did apply to some, but not all, retained lots in the subdivision, as long as the entire subdivision and retained tract were part of the restricted district. The case was remanded to the court for reconsideration based on the Supreme Court's opinion regarding factual sufficiency.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.